you for joining Jennifer Schaus and Associates in our 2019 Webinar Wednesday series. We are coming to you live from downtown Washington, D.C. Our webinars are held every Wednesday, and you can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email her with the contact information you see on the last slide. All right, and just a little bit about us. We are a Washington, D.C.-based firm and provide services to federal contractors. This ranges from market analysis reports to proposal writing and post-award compliance. More information is on our website, so please visit us. We have an upcoming event on August 6th, which you can find more information here on this slide or on our website. And we are now offering advertising in our newsletter and webinars. You can contact me if you want more information. And our webinar today is sponsored by AccuTrack, and here's a short message from them.
AccuTrack Consulting and Accounting Services is an Inc. A WOSB CPA firm committed to supporting entities sustain growth in government contracting. Our outstanding DCAA accounting solutions reduce audit risk, improve cash flows, and give you peace of mind. Contact us today to learn how we can enhance your DCAA accounting efforts.
Okay, so let's go ahead and get started. Our speaker today is Maria Panicelli, and we are going to be covering partnering in GovCon, best practices in teaming. And Maria, I'm going to go ahead and hand it over to you.
Thank you so much, Mallory, and thank you everyone out there for joining us. As Mallory said, we're going to be talking today about teaming. This is part of a two-part series today, and the second part we're going to be talking about joint ventures and mentor-protege. Next slide, please. So before we get started, a little bit about me. My name is Maria Panicelli, and I am a partner and the chair of the government contracting group at the law firm of Obermeyer, Redmond, Maxwell, and Hippel. I concentrate my practice exclusively on federal contracting matters, and I advise clients throughout the entire life cycle of their contract with the federal government. That includes things like dispute resolution, REAs, claims, bid protests, etc. But a big part of my practice is also the small business procurement piece, and obviously a large part of that, especially with recent changes to the regulations and developments in the industry, is teaming, joint venturing, and mentor-protege. So today we're going to talk about teams, and this is kind of just an overview about what I've found working with my clients really are the secrets of successful teams. And we're going to go through each one of these kind of in order, but as by way of agenda or overview, I think the first part is that it's important to understand the fundamental concepts and building blocks that you are relying on or that are coming up in context when you're talking about teaming, joint venturing, or mentor-protege. I think it's also very important if you're going to succeed and have a successful team that works well together and stays on the right side of all the regulations, is to really understand and focus on the why. Why are people teaming? Why is it good to team? What is the purpose of teaming? Then we're going to talk a little bit more about some more nitpicky procedural things, differentiate between teaming and joint ventures, learn best practices for teaming agreements themselves, and then we're going to talk just a little bit about common pitfalls and how you can avoid them. Next slide, please. So the first thing that I mentioned is it's really important to understand the fundamental concepts and building blocks of teaming. One of the things that's really important to understand is the lingo. A lot of times you'll hear people use the term teaming as kind of an umbrella term that encompasses different types of partnerships, teaming, GSA CTAs, joint ventures, mentor-protege relationships, etc. But the reality is that they actually are distinct concepts. They are distinct types of relationships. They're set up differently, and they are ruled by different regulatory bodies, and therefore there are different concerns that come into play depending on what type of partnership you enter into. So the first difference is to understand just pure nomenclature-wise, pure naming-wise, what the difference between teaming and joint ventures are. Teaming is really just a special type of subcontracting. There's still a prime contractor, there's still a subcontractor. One of those entities, the prime contractor, is the entity that contracts directly with the government. and the other one has a subcontract and doesn't have any direct relationship with the government. Joint ventures are a little bit different because in those scenarios, two or more companies come together, and then the joint venture entity is the prime contractor. And the joint venture goes after the independent relationships and the contract with the government. You don't have a subcontracting relationship. So that is very important to keep in mind. In addition, it's important to keep in mind what context these relationships often come up in. Now, yes, teaming and joint ventures can be done on pretty much any project at pretty much any time. You could have two giant companies. You could have, Northman and Lockheed doing a joint venture for a project. There's nothing that prohibits or limits joint venture and teaming to the small business set-aside context. But where you most often see teams and joint ventures, or where you most often see teams and joint ventures that get a little bit complicated at least, are in the small business context. And that is because for set-aside contracts, obviously you have eligibility concerns that large businesses cannot fulfill. If you're working with set-aside contracts, there are only certain types of entities that can bid on those contracts, whatever type of small business it's set aside for. So that means that, these concepts come up often because large businesses and small businesses, or different combinations of businesses, are trying to come together to compete for those set-aside contracts and do so in such a way that allows the small business or the team or the joint venture to maintain small business status. So that's one of the most fundamental concepts that kind of runs through all of this. The reason that mentor-protege and the mentor-protege programs are often talked about in the same context, are often kind of put under that umbrella of partnerships or teaming, quote unquote, is that, and we're going to talk about this more later in the presentation, sometimes the mentor-protege relationship is a prerequisite to forming a joint venture if you want the joint venture to be able to go after small or other types of set-aside contracts. That's not always the case. We're going to talk about when that is the case and when it's not as we go forward with today's webinar, and then later in part 2 of today's webinar. But that's why you often hear mentor-protege discussed kind of in the same context as joint venturing and as teaming. But it's important to understand, as one of those fundamental building blocks that we talked about, that the mentor-protege program is not designed just as a vehicle to get these joint venture or teaming contracts. And common misconception, forming a mentor-protege relationship and having that approved by the SBA isn't the end. A lot of people will say to me, I'll have clients or potential clients call me and say, we've formed a mentor-protege and now the mentor-protege payer is going to go after a contract. Well, the mentor-protege payer are still two separate entities that have no contractual relationship with each other. So if you form a mentor-protege relationship, that's great, but then you still have to either form a team or a joint venture to compete for those contracts. Next slide, please. So another one of those fundamental concepts that I talked about, and the idea that, like with anything else in the universe, really helps to understand the purpose or the why underlying these types of relationships. That will help you figure out, how to govern them, and it will kind of help guide your instincts as to what's going to be acceptable and not acceptable when forming these relationships. So why team? Or why joint venture? And we'll talk today about the differences between those and when, which is appropriate. But the reason that this comes up, again, in the small business context, is that with the rise of the set-aside contracts, more contracts are being set aside for small businesses, meaning that large businesses are losing contracting opportunities. Small businesses have the ability to compete for those set-aside contracts, and large businesses don't. So the rise of set-aside contracts means large businesses are looking for a way in. How can they get some of those small business set-aside contract dollars? Meanwhile, small businesses are sitting back and saying, great, I've got the eligibility. I can go after these small business set-aside contracts that I'm eligible for. But maybe I'm a little too small to perform them, or at least perform them in the time or the manner that the government wants. Maybe I don't have the capabilities. As there's been kind of a push towards contracting by negotiation and other type of FAR procurements, FAR Part 12, 13, 8, GSA, FSS, etc., and less focused on sealed bidding that's only about lowest price, there's been an increased importance of non-price evaluation factors. So things like past performance and key personnel qualifications and other things that maybe small businesses do not have as strong a track record for. So while the large businesses are looking for a way in, a way to get a foothold and get some of those dollars that have been associated with set-aside contracts, small businesses are looking for a leg up on the competition, a way to beef up their stats and look more competitive with regard to non-price and sometimes even price factors. Next slide. So that means that the most common type of team that you will see in this small business set-aside context is that a large business will leverage their small partner's eligibility and a small business will leverage their large business partner's capabilities. So what does that mean? Again, if it's a set-aside contract, only the small business has the eligibility to compete. So the small business is going to be the prime contractor and the large business is going to be the subcontractor. When I first started practicing in this area of law, that seemed very counterintuitive to me, that you would have, a small guy at the top of the pyramid and a large company answering to that small guy. But again, keep in mind the context and the why and the eligibility issues that come into play, and then you will understand why the small business needs to be the prime and why the large business is the sub. As I said, obviously other types of teams exist. There are teams between large companies, teams between two small companies, teams between a number of companies. There are CTAs for the GSA schedule contract or GSA or other procurements that are procured under the GSA schedule contract that operate differently. But we're talking about common teaming in the set-aside context today. Next slide, please. So the next decision you have to make when you're looking at a partnership, one of the things that's going to come up is, all right, do I want a team or do I want to form a joint venture? And as I said, we're going to be concentrating in this first part on teaming, and then the later webinar today will be following up with some more information about joint ventures and mentor-protege relationships. But in order to figure out whether teaming or joint venture is better for you, you have to understand some of the important differences between teams and joint ventures. As I kind of alluded to earlier, one of the biggest differences is who is the prime contractor. In a team, you're going to have a prime and a sub. The small business is going to be a prime. The large business is going to be a sub. In the joint venture, you're going to have the companies come together, form a joint venture that's owned partially by each one of those joint venture partners. The joint venture is going to be the prime. But that means that you've got different, levels of control and different levels of, interest in those companies. So it's going to be something that you need to talk about with your potential partner and figure out, do you want to set it up as a prime sub relationship or as a joint venture relationship where there's a little bit more shared? Obviously, another difference between teaming and joint ventures, teaming, the companies stay separate. Joint venture, you've got a new company that's kind of an amalgamation of the two companies. There's a lot more interaction. It's a much more formalized relationship. There's a lot more sharing of information. What do you want to do? Is that the type of relationship you want to have? Timing is another issue that you need to keep in mind. Generally speaking, if you're going to go through a teaming arrangement, that can be done and the negotiations can be effected, I would say, relatively quickly. Obviously, negotiations happen, but especially if you're on the same page, because, as I just said, the companies are still operating as separate entities and it's just a special type of subcontracting relationship. Teaming arrangements, in my experience, don't get that contentious, so the negotiations don't last that long. Joint ventures, there's a lot more to think about. There's a lot more permanence. There's a lot more formality. There's a lot more going back and forth about who's going to control the joint venture and what that control is going to look like and, how things are going to be paid for. So negotiations can take a lot longer. Moreover, as we're going to talk about later today, sometimes you have to form that mentor-protege relationship before you go for a joint venture. So all of that to say, you have a much longer lead time, or can have a much longer lead time when you're going after a joint venture project, or when you're going after a project as a joint venture, I should say. So if you've got a specific procurement in mind and that procurement's going to be dropped soon, you need to think maybe teaming is better than joint venturing. Another thing to keep in mind, if you've got a specific solicitation in mind, is to check the requirements of the solicitation and see what they say about, counting a teaming partner or a joint venture partner's past performance. Some solicitations will not allow you to leverage a teaming partner's capabilities. And again, remember those fundamental building blocks that we talked about. The purpose, oftentimes, of a team is for the small business prime to leverage the capabilities of their large business sub. If the solicitation is not going to let you do that, maybe a joint venture is a better idea. The regulations were recently updated to, allow for the consideration of both joint venture partners' individual experience whenever a joint venture applies, or I should say submits a bid or a proposal. And again, still worth checking your solicitation to see if perhaps someone cut and paste old regulation language that's not consistent with that. But anyway, those are the things that you're going to want to think about in terms of deciding whether you want a team or joint venture, or I should say some of the things that you're going to want to think about. You're also going to want to perform a realistic assessment of performance abilities and compare that to requirements. The key is really to openly and honestly discuss goals and limitations. I've done presentations like this before, and one of the things that you hear all the time from lawyers, from proposal experts, from government people, from successful teams, is that you've got to treat it like a dating or a marriage relationship. If you're not open and honest with each other about what you want, what your strengths, what your weaknesses are, those things are eventually going to come to light, and it's just going to make the team an unsuccessful team. So discuss openly and honestly, what your goals are, what your partner's goals are. Discuss what the capabilities that you have are, and what your weaknesses are. That way you can structure a teaming agreement and a subcontract that you'll actually be able to comply with and won't get into trouble down the road. It doesn't make sense to kind of hide the ball during the open negotiation phase because it's going to come out and then the team's going to falter, or you're going to have a problem with performance. So it's really about realistic assessment, open and honest communication, and also kind of thinking your way through all of the potential contingencies that could come up. Once you do that, you should be able to choose a path and figure out that based on what you want and what your potential partner wants, if teaming is appropriate or if joint venturing is appropriate. Next slide, please. So, some critical concepts that you want to keep in mind when you're talking about the actual negotiation of teaming agreements. The first, and I'm going to talk about this from the small business prime's point of view first, is exclusivity. Remember, I just said you want to treat this like a dating relationship. What would most people tell you is a critical conversation to have at some point in any relationship? Are you exclusive? Are you seeing other people? What you will see oftentimes, remember those big businesses, they want to get their foot in the door. They, are only teaming so that they can get some access to to small business set aside contract dollars. That means that it's very possible that large businesses that want to be a sub on a particular project are going to go to numerous small business contractors and say, hey, do you want to form a team? In that way, the large businesses are protecting their interest. It's entirely legal. It makes sense. It's just good business judgment. If you know that there's an 8A set aside that's coming out in Augusta, Georgia, and that you think that there are 3 or 4 8A contractors that are going to go after that procurement, why not shop yourself around, see if you can get a teaming arrangement put together with all of them? Then no matter who wins, you've got the subcontract, you've got access to those dollars that would be coming in that you wouldn't otherwise have access to because you don't have eligibility to compete as a prime. That's great for the large business prime, for the large business subcontractor. It is not so great for the small business prime. Remember, fundamental concepts. What is the small trying to do? Get a leg up on the competition, leverage their large business capability, their large business partners' capabilities. Well, if all of their competitors are also leveraging the same partners' capabilities, they're not getting a leg up on the competition. So if you are a small business prime that's looking at entering into a teaming agreement, you're going to want to have those open and honest dialogues with your teaming partner about whether or not they are willing to have an exclusivity arrangement with you, or whether they're willing to have some sort of exclusivity arrangement with you. In other words, this is an IDIQ. We won't team with anyone else for task orders in Augusta, Georgia. But if it starts going to the Carolinas or Florida, depending on the scope of the IDIQ, then we don't have exclusivity anymore. Or, for the next year, we're not going to team with anyone else. But obviously there are task orders that can come out under this IDIQ for 3 years. So after that year, we're allowed to team with someone else, etc. Negotiate the exclusivity. And this, in my experience, is something that should be discussed sooner rather than later, because this can be a non-starter for some people, and there's no point in carrying on negotiations and wasting time if this is going to tank it eventually. Enforceability is another concept that's really important. A lot of courts, when looking at teaming agreements, will look at whether or not they are actually enforceable. In other words, can you hold them to it? And this is something that's probably more important for the large businesses that are going to be performing as subs. Because what they want is a guarantee that if, they put the effort into helping their teaming partner prepare this proposal, the teaming partner, the small business prime, has leveraged that large business's capabilities to get the contract. The large business wants some sort of guarantee that if the small business gets contract award, they're going to turn around and actually issue a subcontract. So if they don't, what are their options? What are the large business's options? Well, it would be to file some sort of suit trying to enforce the teaming agreement. That's why enforceability becomes important, especially for the proposed subcontractor or large business teaming partner. Keys to enforceability are to use very specific language. Courts don't like when teaming agreements are vague. They will say that's just an agreement to agree. So things such as, well, if we get the contract award, we think we will probably give a subcontract to these, large contractors. That's most likely not going to be enforceable, at least in most courts. On the other hand, compare that to something like when awarded, if and when awarded the contract for solicitation number X, we will, within X amount of days, enter into a subcontract with this large business. That's going to be deemed a lot more enforceable. That's a lot clearer about the party's intent and shows that the parties have an intent to be bound to each other, and that they actually contemplate entering into an arrangement. Next slide, please. So again, best practices for teaming, you're going to want to think about those two concepts that I just went through, enforceability and exclusivity. You're going to want to make sure that, again, communication is open, honest. That's critical to whether or not you're going to put together a successful team. You're also going to want to discuss other key issues: scopes of work, goals, capabilities, limitations, etc. The more specific you can get about those concepts, the more you're going to be able to put specific terms in your teaming agreement, the closer you are to enforceability. In addition, the more specific you can get in terms of negotiating scopes of work, goal, capability, etc., then it's going to set you up for really easy subcontract negotiations, or, as we'll get to in just a second, maybe even drafting a subcontract and attaching it to your teaming agreement and saying, hey, look, we've already done all of this work. This is how we're going to work this out. That's also going to give the government a lot of confidence that you guys have really put a lot of thought into your teaming arrangement, and it's most likely that you're going to be able to work together as a good team. In addition, you're going to want to think about the scope and the length of agreement. That's kind of what I was alluding to before. How long does this teaming arrangement last? Is it for just one task order or numerous task orders, or only certain task orders in a certain geographic area? What about exclusivity? What's the scope of that? Is it just for this contract? Is it for all contracts that the VA puts out for the next 3 years in Mount Lebanon, Pennsylvania, etc.? You're also going to want to plan for certain contingencies. One thing that I see people forget about a lot is what to do if you end up not getting the contract. As many of you probably know, there's a process called bid protesting. And oftentimes what you will see is a team will put in a lot of effort, put in a bid or a proposal, and if they don't get the award, the large business, who might be more used to protesting and might have a legal budget, says, well, this is ridiculous, we want to protest. And the small business says, I would have loved to have this contract, but I don't have the money it takes to protest this. Well, maybe you want something in your teaming agreement that talks about who's got veto power, who's got the power to decide that you're going to protest, and maybe who's going to pay the legal bills if you do decide to protest. Again, that's planning for worst case scenario, but it's important to do that so that you can kind of make sure that you don't have an argument down the line about an issue that you didn't think of. You're also going to want to think about the fact that, when doing a teaming arrangement and cooperating on a bid or proposal, there's going to be a lot of sharing of information and sharing of resources. What measures do you need to take to protect your confidential or proprietary information, or to, deal with other competition concerns? You might want to have an NDA in place. You might want to have some sort of confidentiality agreement in place. You might want to have some sort of non-solicitation or non-competition agreement in place to the extent that it's enforceable and ethical in whatever jurisdiction that you are dealing with. So these are just other concerns that, again, you're going to want to think about in terms of a teaming arrangement. Obviously, the scope of work, what you're going to be doing, what the projects are that you're going to be competing for. There are going to be things that everyone thinks of, but little things like the scope and the length of the agreement, what to do in the case of bid protests, how to handle certain other issues or pitfalls that come up, and also how to protect each party's confidential information should also be critical concerns. Next slide, please. So how do you, encompass all of this advice? Vague is the enemy. Get specific. Drill down on concepts. Talk about scopes of work. Talk about your capabilities and what scopes of work make sense. Talk about the regulations and what percentages of work they require you to perform. There are regulations that talk about how much work a prime contractor has to perform on a set-aside contract. Make sure in divvying up the scopes of work that you're being compliant with those regulations. In terms of enforceability, also, you don't want to be vague. Use mandatory language. I shall or I must enter into a contract with this subcontractor if I get a contract award. Even more mandatory, put a date line on it. I must within 5 days issue a subcontract to this particular subcontractor if I get the award. Even more specific, I must within 5 days issue a subcontract in a draft attached form. Attach a draft subcontract to your teaming arrangement. That's all going to go to the enforceability issue. Be specific about scopes of work, both define the scopes of work, kind of lay out the specific tasks that are within those scopes of work. Be clear that you plan on complying with the applicable regulations, state the percentages of those regulations, and then describe in narrative form what you're going to do to comply with those narrative regulations. Obviously, that's a lawyer's point of view. That might be a little bit seeming like overkill to those of you who are contractors out there, but I've seen it work, and I've seen, the more specific you are, it also helps you out to be a little bit more protest proof if you get a size or status protest. So that's why those are best practices. And again, engage in open and honest communications. That's really the key. You never want to be hiding the ball from your partner, and you never want to be hiding the ball from the government. The more open you are, the better chance you have of having a successful team, and the better chance you have of that team performing successfully to the government's satisfaction, which helps both parties. So with that, real quick, just want to talk about what can go wrong with teaming. The possibilities for going wrong are affiliation, control, and percentage of work. As long as you consult, your local PTAC or a consultant or a legal expert, make sure that you set up your teaming arrangement correctly. You can hopefully avoid any affiliation or control concerns. And if you deal with the scopes of work in the way that I have said previously, you should be able to also address any potential problems there are with regard to percentages of work. So with that, my information and obviously Schaus & Associates information is up on the screen. If you have any further questions, feel free to reach out to me. I will now turn it over to Mallory for a wrap-up.
Thank you, Maria. Thank you for sharing your knowledge and insight today. Today's presentation has been recorded and can be found on our website or YouTube channel within about 48 hours. If you have any questions about today's topic, please contact Maria with the information you see on your screen. Thank you, everybody. This concludes the webinar.